Hey guys, Dark Angel here. As I mentioned in my very first video, I told you that I would bring to light information about a previous case that actually was admitted back in March 27th, 1986. Young lady by the name of Julie Ann Port out of Spokane, Washington. She was the young lady. She appealed a decision about a case about rights to drive without a license, registration, insurance, etc., etc. Now this is my version. I copied this straight out the book, but I titled it with study purpose only, based on the fact that I am actually studying this case to determine how she lost the case. However, I didn't have to do all that because it actually says it in the case why she lost. What I have here is the opinion of the judge who is telling you why she lost her case, which is strange because judges usually won't tell you why you lost. They'll give you a reason as to the decisions made, you understand, whether or not your case had merit or if it was frivolous or whatever, in standing to that regard. However, in this case here, her loss was so simple that had she taken more time to actually look at her brief and prepare her brief. Now, she filed this brief pro se, her appellant brief pro se, which under the law pro se, you're not held to the guise of that of a seasoned attorney. However, if you don't enforce the fact that you're pro se and that you shouldn't be held to those standards of attorneys, they will hold you to the standard of an attorney. So therefore, you want to make sure that if you do decide to challenge a constitution, or when you are ready to take on the challenge of an appeal from your actions of not driving without a license, registration, insurance, you want to make sure that under the act of pro se, go in and find the case. I do believe it's Young. I'm not sure right off the top of my head. You want to make sure that you stress this to the court, that you are not seasonally challenged as an attorney, and that you are arguing the case to the best of your ability and knowledge and understanding as to how you see it or how you have read it. Okay? Again, I need to tell you, in order for you to win this case, it's about presentment. How you present the case, what you are arguing in the case. Okay? You have to know what you are arguing. You need to comprehend it. You need to discern the difference between cases and know that this case represents this or this case represents that. You need to understand all that because they're going to expect you to. With that being said, I want to get into this case because I don't want this video to be too long. I want it to be short, simple, and straight to the point. Basically, what I'm doing here is pointing out pointers to anyone and everyone who is about ready to go in and challenge this case. Now, you can do all the other things you see on YouTube and try all that if you'd like. That's okay. But this is just to give you some pointers, some tips on what to and what not to do. Okay, in this instance, her case, the woman admitted that the state should have some right. They gave it all away. She should have denied the state any right and argued that any private dealer should provide training to avoid the legal trap of admitting the state has any right to license or otherwise deny the right to drive. When you give the right to control who drives away in any form, you are allowing them to convert your right into a privilege. Privileges may be taxed or denied. One can also rescind or withdraw a license and application after having passed the driver's test. Basically, what she did here was she said that she didn't qualify under the fact that she needed a license based on the fact that she wasn't driving commercially. Ladies and gentlemen, that argument is so old. It's played out. Okay? There is no more argument where you can argue that because you're not driving commercially, you do not require a license. Okay? All 50 states issue non-CDLs versus CDLs. Okay? Our state is a Class D, non-commercial license. Then you have Class A, B, and C. Okay? So that argument is played out. People telling you, well, yeah, it's non-commercial. No, not to any degree. It is not true. There is a such thing as non-CDL license, and that's the license that they're holding you by, the standards that they're holding you by. However, in general, in retrospect, or however you want to title it, all licenses are illegal. Okay? All licenses are illegal. It don't matter who issued it. It's all illegal. Prove driving competence by taking driver's tests, passing, then canceling the license and withdrawing the supposed relinquishment of the right, or also claiming to reserve under the Uniform Commercial Code 121-207 preserves all civil rights. The right, even if privileged, they can take the privilege, but the right still exists. True. That's true. Basically, what she's done was she took away the driver's license and just retitled it a certificate of competence. That's all she did, and that's the reason why the state stood behind its ruling to not grant her petition, because she still gave the state permission. She still gave the state the power to issue. All she did was change the name of license to a certificate of competence. Let me show you how to get rid of that argument of certificate of competence. I don't know how it is in other states, but you can check with your DMV or your Department of Transportation or whoever it is that takes the statistics on annual fatalities that occur in your state. Now, the argument by the state is that the reason for licenses is for public safety, to knowledge and understanding of the highways and byways, etc., to prevent accidents, to prevent traffic infractions per se. So I called my state DOT office and I got the study from them. And I was actually shocked to find out that 86% of the fatalities that was caused on the streets in Washington between the years 2016 and 2020 was caused by privileged drivers. 13% of that only caused by non-privileged. Now I have to ask myself, how in the world did the safety for the public work? Seems to me like the privileged drivers are the ones that have the most issues with accidents. So if you present that in your argument, actual statistics that came from your Department of Transportation or whoever keeps the fatality statistics in your state, and it proves that privileged drivers have caused more accidents than non-privileged drivers, that takes and renders the state's argument meritless, because they don't have a leg to stand on. There's no support for it. They don't have any support because the facts come straight from the state. So with the facts coming straight from the state that you're presenting to the court, guess what? Decision goes in your favor. So with that being said, hang on one second. I'll be right back. Give me a second because Dark Angel's got to let the dark cat out. Come on, dark cat. Come on. Go on. Go on. Look, I'm not going to sit here and play this game with you. Go on. There you go. Jeez. All right, my apologies. I'm back. So, back to the lecture at hand. So, as I was saying, so as long as you present that as part of your argument, okay, you give yourself credibility. Also, too, you have to keep in mind that when you're arguing this case, even though she used the case, I believe it was Smith versus Thompson, right, in this case, unfortunately, she argued the wrong case law. Smith versus Thompson supported so much, and then one of the other cases she used was Chicago versus Banker. Well, these two cases were the wrong. Those are the wrong cases. You know, you want to use other cases. Basically, what she did was she found the first case, she bid on them, and she tried to build her case off of those two cases. I'm being brief about this because this video is getting ready to be long, and I'm not trying to do that. So, another thing that she failed to do was she never alleged one time in her petition that license requirement was unconstitutional. Listen, again, what did I say? I said it from the very beginning. If you do not word your words correctly, word your petitions correctly, the state's not going to give you the words. Okay? They're not going to tell you, well, you should have done this, you should have done that. After the fact, after everything's said and done, sure, they will, in their opinion. They'll tell you, well, you know, if you had done this or if you'd done this, this could have occurred. If you'd done this, this could have happened. Sure. They're not going to tell you. They don't want you walking in there expecting training by them. Okay? Not going to happen, people. It's not going to happen. So if you're expecting to walk in there and they correct you on the laws, they're not going to do it. They're going to rule because of the simple fact is you have not provided any proof to substantiate the claim that you are making. And by her having not alleged that the issuance of a driver's license is unconstitutional, she loses the case. Based on this fact, she has not supplied any case law that supports her argument. And the argument is clear and simple. You took a right, you turned it into a privilege. Then you took a right and turned it into a crime. That's the argument. It's simple. Simple math. If you want to call it math, it's simple. Right to privilege, right to crime. Okay? She didn't mention any of this. There's ample case law in here showing that right to privilege, right to crime, or right to privilege, right to crime, you know, is not allocated by that, is not allowed by that of the state. The state, there's no case law that supports that, and they would not be able to argue that. That's the point I'm trying to get across to you. If you present your case in reference to that fact, that a right turns into a privilege by the state, and the state turns a right into a crime, who gives the state that authority to do that? What gives that state that authority to do that? To commit this deprivation of rights? Under what authority does the state have that right to do it? Guess what? There is no case law that substantiates their right. You just took away their public safety argument by contacting the Department of Transportation and finding out what the actual statistics of fatalities between non-privileged drivers and privileged drivers are. So hopefully in your state or wherever you are, with the statistics provided from that fact, it supports what you're doing. However, even still, regardless as to that argument, oh, it's a public safety issue. No, it's not. That's an excuse for you to utilize and say that is the reason why you need to administer a license. Again, under whose authority are you authorized to take a right and turn it into a privilege? Never steer away from that argument. Steering away from that argument can lead you into a dead end, and you don't ever want to do that. Never steer yourself away from your point of origin that you are trying to present in your case. The whole point of your case is to express the fact that you would like to know under what authority gives the state the right to take a right and turn it into a privilege, okay? And then take a right and turn it into a crime. Under what authority? There is no case law. There is no statute, there is no policy, there is no regulation in support of this. I promise you. It's 100. 100 people. It's 100. Unfortunately for Miss Potts, she didn't win her case just based on mere words. She gave them an in. She gave the state an in to get in. And the in was, she said that the state should have a right to admit a certificate of competence. State has no right. State has no right. 14th Amendment specifically states that you have a right to free domestic travel. Now, translate that in today's terms, travel means to go from point A to point B, place to place, and take your property and your vehicles and your deals and go on about your merry way. Freely, without government intrusion, interference. Well, guess what? By having a license issued, that's government supervision. A right you waived when you signed for that license. You have a right to no government intrusion. It's the law. Supreme Court law has ruled on it. Hundreds of cases, people. Go look them up. There's hundreds of cases in support of that. The fact of the matter is that you can drive without a license is true. You can drive without a license. You're going to dig through high water and hell to get there to that point. But the point is, if you argue your case correctly, you will win. Again, I'm going to stress this in this video. If you present your petition to the court correctly, and remember, right to privilege, right to crime, that is what you are basing your deprivation of rights on, you will win this case. You can win, and you win, it will be monumental. It will be a landmark case, ladies and gentlemen. It will be landmark. Trust me, when you see all these people on YouTube and they're talking about, oh yeah, they won this, they won that. If they did, how come it's not a landmark case? Because a landmark case is going to set precedents. Trust me. It's going to make the news. It's going to make history. Has anybody ever seen any one of those YouTubers on there make history by making this claim of, oh yeah, I won this case of driving without a license? It's not in the law books. Oh, you mean you won it on the streets? You didn't actually go into a courtroom and execute a petition to challenge the constitutionality of a revised code or a statute or a penal code or a law that's in place that takes your rights and turns them into privileges and or rights into crimes. You haven't actually went into a courtroom and challenged this, right? So you just did this on the streets. That don't count. Okay? That don't count. What counts is getting on the court docket, having that case heard, having that case officially decided. That's what counts. And to all you non-believers out there, keep non-believing. One day it's going to happen. And I'm going to say, for all you non-believers, because all you people are the people that want to sit back and reap the benefits from other people's doings. That's what you are. And that's sad that you would be those people. You'll sit there and you will troll Facebook, you will troll YouTube, you will troll in comments and make bad comments and negative comments. But as soon as something good happens from what it is you're trolling about, you're right there with your hand out. So you trolls, you reapers of other people's doings, hey, get it how you get it, I guess, huh? But there's some of us out here that's actually trying to do something. Okay? The government is slowly stealing away your rights. And it's not just the right to drive without a license, it's other rights that we've had all along. And the government is slowly taking them away from the people because they want to be able to control the movement of the people. They want to know where you're at all times. They want to know what you're doing at all times. Even in your private capacity now, they want to know what's in your privacy of your car. You got tinted windows, they ask you to roll your windows down because they want to be looking all in the back seat of your car. That's my personal property, my private property. You have no right to look in my car. It may be on a public street, but it is not within your visual cortex, so therefore you have no reason to be looking in my car. That's another argument, another time, etc. But the bottom line is, people, like I said, I'm going to cut this video short, is if she hadn't argued that the state had a right to issue a certificate of competence and stuck on and picked up the argument, right to privilege, right to crime, which probably back then in the 80s, she probably didn't even know what that meant, because I don't believe that even came out until sometime in the 2000s, I believe, that it was finally realized. I think it was actually realized back then, way back then, actually. I'll be honest with you, I actually do believe it was argued way back then, but I don't think that it ever rose up off the ground because it was never founded as to what the facts or basis of the cases were about. A lot of cases weren't even heard. You have a lot of cases where people wrote cases, they submitted petitions, etc., but none of them was ever heard by the Supreme Court. None of them ever made it through the front door. So therefore, these cases that are floating around are cases that have never been decided on. So, when you allow for the state, in her case, she said that the state should just be allowed to issue a certificate of competency. Young lady, what you did now was you still gave the state the power and permission to issue a certificate of competency that just gave the driver's license another name. All you did was rename the driver's license to a certificate of competency because you wanted to argue that you're not traveling in commercial capacity. That argument no longer stands. It doesn't hold no weight. It's frivolous, people. The Constitution, the Supreme Court laws, and all that, even though they have been argued and support the right to travel in your private capacity, etc., what they're not telling you is that there is a non-commercial license and a commercial license. That's what they're not telling you. That's the part everybody's not understanding. You're talking about traveling in your commercial capacity. The law says that if you're going to travel on the roads, you need a license. Well, guess what? They issue a license, a non-commercial license. They do issue them. Every state does. So your argument is frivolous. It holds no merit. It has no weight because you're arguing away. Okay? What you need to be arguing is the fact is who gave the state the authority to take a right and turn it into a privilege and take a right and turn it into a crime. Okay? That's all you need to do. That's all you need. Until next time, hey, this is Dark Angel, man. Peace, love, and happiness. And everybody just be cool. Ciao.